Welcome to week 7 or week 15 employment law in MCC's Business 241 class. My name is Mary Ambrose Durack. This is my favorite week to talk about because this is my practice area of the law. I am a retired former EEOC prosecutor as well as an employment lawyer currently. I'm one of the 30 arbitrators in the United States that handles AAA employment law cases. And I've done investigations of Cook County and other municipalities for employment law hiring mismalfeasances. And I'm very happy to share with you what chapters 39 and 40 in whatever edition you have of Anderson and Toomey's business law has to say about employment law. Many students say to me, I can do whatever I want in the workplace. And that's what employment at will means, which is the bedrock doctrine for employment law. The concept, and different states, the United States are employment at will states, has to do with a duality of a relationship. Yes, you can quit your job anytime you want, but yes, the employer can also fire you or RIF you or downsize you, RIF meaning reduction in force, anytime they want. So this notion that you can do whatever you want and that this is a free country is somewhat mitigated by the concept of employment at will and employment at will states, which Illinois is one of them. The other situations that affect the employment relationship have to do with employment manuals, policies, and contracts. And what do we mean by employment manuals, policies, procedures, and contracts? An employment manual might set forth an agreement between the employer and its employees. It might say, if I terminate you, you're going to get 2 weeks severance for every year that you serve. That would be something different than the basic employment at law relationship. There might be a policy that says, if you work at this particular company, everyone wears this uniform. Those are things that affect the employment relationship and affect the freedom that many employees think they have in the workplace, where your employer has the right to tell you certain things about how they want things conducted in their restaurant, in their business. There might be procedures that you're required to park in a certain place, that if you want to exercise, you get this much time off during the day to do that. You might also have a contract. Many people will say to me, I never got an employment contract. They don't hand out employment contracts. And I'll go back to them and say, did you get an offer letter? And they're like, yeah, it said my salary was X, I start on this date. I said, did you read the offer letter? And embedded in the offer letter are many promises from the employer to the employee and the employee to the employer as well. If you go into the workplace on a writing like that and you start to perform the job, one written document without your signature on it and performance equals a contract. So you may want to pull out your employment offer letter and at this point in your career, see how much it adds up and confirms things that you were promised in your manual, your policies and procedures, as well as things that you thought you negotiated by that little email that you sent out when you started the job. So these are things that temper the employment at will relationship, and they do give the employee, which I'm going to refer to as with an EE, some rights. So another key document that's oftentimes handed out to employees when they start to work is a document that's called a non-disclosure agreement. It's called a trade secrets agreement. People say to me, I don't remember getting anything like that. And yet I had one student come into my classroom at MCC with a 30-page document on trade secrets, and he worked at a very well-known national restaurant chain. He goes, you were right, I got a trade secrets agreement. And I said, okay. And he said, can you look at it? Can you tell me what it says? I said, yeah, it says you got to keep a lot of things secret. And he said, what do you mean? I said, I don't see anything that says here what they taught you that was secret. So if you work for the Colonel, or you work for another restaurant chain and they have a secret way they make their chili or their sauce that goes on their Big Mac, and they let you in on that secret, you may look back in any of these documents or in your what we call TSA, your trade secrets agreement, or your NDA, non-disclosure agreement, and see if you actually promise to keep anything secret. Oftentimes when you're terminated from a place, they'll give you those documents and ask you to re-sign them again, but you may not have known what it is you were supposed to keep secret and what you learned along the way. Those become very important, especially if you decide you want to go work for a competitor. Other documents or policies that will affect your working relationship beyond the employment at will concept include things like the Federal Labor Standards Act has wage and also our local state, Illinois, wage and hour provisions that govern your employment. They have websites, they have free question and answers that you can ask anonymously and get some advice off of the Illinois Wage and Hour website. And what do we mean by that? Little known to some of my clients, in Illinois, when you're terminated, you are to get all your vacation pay in a lump sum the day that you're terminated. Not 6 weeks down the road when somebody remembers, not 6 months down the road, but the very day that is your last day at a company. That's a law that the Illinois Wage and Hour folks have on the books to protect employees. There are also rules about rolling over vacation from if you don't use it from 1 year to another. These are things that you should check on that help to shape your employment relationship. There are privacy laws, and if you look under the modules for this particular unit, and I think I've repeated it in the intellectual property module as well, people say to me, well, I brought my own cell phone to work. I brought my own computer to work. Can I just put anything on there I want? And can I, hey, this is my computer at work. This is Mary's computer in this room. Can I just download Facebook if I want? There are sites that you are not able to access, I'm certain, at MCC. Or if you do, you could get in trouble. And those would be ones that you would think would be inappropriate for work. So do you have unlimited privacy in the workplace? Do you have an expectation of privacy? I remember starting it with one client and they said, we think that there's theft here. Can we therefore put cameras in the bathrooms to see if anyone's taking stuff in there and stuffing it in their clothes? And these kinds of questions, cameras can be used and are used much more prevalent in the workplace. It's a great article under supplemental reading for this class if you want to know the answer to that in all of its context. You do furnish I-9 information, 2 documents to prove that you are fit and able and have all the legal paperwork in order to work in the United States. Those particular documents are monitored by the Immigration Naturalization Department and also many others that you hear about currently. Can an employer check your credit? Yes. Do they have to disclose that they're doing that and have you sign off on something? Yes. Can an employer drug test you? Yes. I went and worked for one particular company that cut out my very long hair that you're seeing on this video, cut out an entire length of my hair, and it took me a long time to grow that back in the back of my head. There are other companies that shave your legs and take the hair off your legs to do drug testing. Can you object to that if you want to work at those companies? No, that they get to choose the way that they drug test, and that's permitted. So if you don't like it, you should probably think about working somewhere else or like short hair. But again, the reasonable expectation of privacy in those articles are on the module for this course. There are other rights that we have, and they become very apparent if there is something that we're going to do in this class as an exercise called the Rif Exercise, or it's sort of when we do it live in class, we do it as an exercise with the students, and it's almost like being on the Donald Trump show and firing people, and we talk about who should be fired and who should not be fired. Hopefully by the end of the class, you'll learn that there's 4 different ways that are in the model ways of coming together and putting together a RIF. Oftentimes, we do it with last in, first out methods in place. The last people hired are the first ones to get let go. Another method we do is sometimes we do certain departments that are related to certain business objectives. But again, what you'll see in these cases is that the business must have a legitimate reason and plan in its to articulate back after an employee argues that they've been discriminated against in some form as they were being terminated. Sometimes There are HR reviews of files to try to come up with what are the risk analysis, and that is going to be the basis of your memo this week, where you look at a particular employee, and in each of the employees we have embedded at least 3 or 4 federal laws that would protect those people's employment. So your paper will consist of describing your employee, describing what their protected categories are, and then in the bottom section you will put each of the 3 or 4 federal laws that would pose a risk of some sort of liability to the company and monetary damages if this particular employee was terminated. So let's go over those federal laws. What I find very interesting about my selection for a career as really the era of employment laws did not start until after the 1990s. So yes, we did have some traditional labor laws like unions that came up out of the trust busting eras, but we didn't have until 1964 any sort of employment laws. And then we added Title IX with the sports and the athletes. But in the 90s, we added these federal laws with these protected categories. Title VII was added. And as such, I will just tell you what some of the protected categories are, and then under Title VII. We protect race, we protect gender, we protect national origin, color, religion, sexual orientation, and as of 2010, we protect genetic information as well. People will say to me there was a time that there was more emphasis at the EEOC for investigating sexual orientation cases, or any of these in certain eras investigated more than another. I did read in the 2016 EEOC report that about 1/3 of the cases were sexual harassment cases. And I don't know, this year might be very different after the plethora of cases that we've seen hit the media. So that some name like Harvey Weinstein has become almost like an employment law term for explaining a certain kind of behavior. In addition to those Title VII protected categories in that era, we added, and these sound like the alphabet soup cases, the agencies and laws that we talk about in terms of what FDR started for our country. We have the ADEA and the ADA and the PDA. Here, the ADA is the Americans with Disabilities Act. Oh, so, and disability is also under Title VII. So there's Title VII protection for disability as well. ADEA is the Age Discrimination Employment Act. And oftentimes you'll see that partnered with the Older Worker Benefit Protection Act, or the OWPA. Again, lots of acronyms, folks. PDA is a pregnancy discrimination separate law with separate penalties, but pregnancy is also protected under Title VII. Those are the laws that all went into effect long after I graduated from Notre Dame's law school in 1987. We also protect, we protect reverse discrimination. So say you're a white male or you're a white female, and we find out that you're not being treated right because of your protected category. We have reverse elements to the protected categories that I just elicited. We also have affirmative action plans, and we've had lots of cases, including the University of Michigan case, that tell us what to do about hiring based on diversity. So these are some of the laws that we will be looking at in more in depth than you'll need to know for the exam, the final exam and the quiz this week. The basic approach to that you'll find if you meet with an employment lawyer is that they'll first sit down and they'll do what I would call, and what you're going to do in your papers, a disparate treatment analysis, as opposed to a disparate impact analysis. And what does that mean? The disparate treatment analysis is just going to ask you, were you ever discriminated against, and run through all the laws and all the protected categories that I've just discussed. Just you particularly. In the disparate impact analysis, the lawyer who's meeting with you is going to say, okay, were all the women at MCC treated this way? Were all the Hispanics at Motorola treated this way? Were all of the employees at Jewel treated this way? And a disparate impact by implication suggests a class action kind of suit. So oftentimes a lawyer will be asking you questions that seem to just ask about you, and then you'll hear a lawyer asking you questions about what goes on in your environment. That is to see if both kinds of violations are in place. If you're talking to a lawyer about sexual harassment, they'll be asking you two types of questions as well in terms of your workplace. They'll be asking you using this Latin term, quid pro quo harassment, and they will also be asking you questions about hostile work environment. Quid pro quo means something for something. It literally translated from Latin. But what is going on here is in quid pro quo harassment, the person has to be somebody that can give you something. Does it mean it has to be your supervisor? No. It could be the CEO of the company, could give you a vacation or a new car. It could be your direct boss, could give you a few extra days off. But what is going on with what they're giving you is they're expecting something in return, and what they're expecting is something sexual. They're expecting a date, a kiss, a dinner. If someone says to you, I won't give you your job review unless you go out to dinner with me, that's an example of quid pro quo harassment. Hostile work environment means, just as it says, that the nature of the place that you work has certain conduct, jokes, innuendos, cartoons, a sign in the bathroom that suggest that that there's some harassing activities going on in the workplace. What I find very interesting when I do my national client training is if you read the case law in different states, while hostile work environment and quid pro quo, of course, mean the same thing, the courts have advanced those definitions a little bit differently. If you look in the Ninth Circuit, Las Vegas, California, it might take one or two touches of someone, more than one touch, to have it be a hostile work environment. If you go to Missouri, you touch someone inappropriately once, that's enough for a hostile work environment. And that's the standard that sort of depends where you are and what the culture of the reasonable person is defined as there. And that's the interesting part of this, especially when I hear the most recent cases and dialogues. What would the reasonable person do? And an awful lot of times you hear the people that are on television, actors, politicians, hotel magnates, whoever they are, saying, I didn't intend that, I didn't intend that. The courts don't look at the actor's intention. They look at the recipient's response to it. And what I find is difficult is, what would the reasonable person say? Maybe in some situations a reasonable person doesn't mind a pat on the shoulder if you just tell them your grandmother died. But other people would take offense with that and say, I don't like to be touched. So how is it that we define what the reasonable person is? And it is a very subjective standard, and that is why you see the breadth that you do in these cases. I'm not talking about the assault cases or the rape cases. I'm talking about the he said, she said, which for a long time were the bulk of the cases that I handled, where there's really communication problems, which is why from the EEOC's perspective in their 2016 report and the United States Supreme Court cases some 20 years before, they said to employers, you don't have a defense under either quid pro quo or hostile work environment unless you train people, unless you do. And now the report that they came out with has like 10 points to training. The training must be dynamic, interactive, regular, done by an HR professional who does training. They've given lots of suggestions, and some of the courts have actually picked up on who can do the training. Can it really be done by the staff internally? No, it can be sponsored by the employer, but he should hire someone from the outside to do it. But we did have a 20-year gap, as I've said on an earlier video here at MCC, where the courts had come out with explaining that if you want a defense under these, from allegations under this, an employer must show that they are taking reasonable steps to do training. And what that consists of, they were very silent on in those cases. And we've taken some time to develop those, as well as this commission for 18 months of the EEOC that came up with what would be acceptable training. Again, I would hearken you back in when you started a company, take a look at what its policy says. Is it a zero tolerance employer? Is it, does it have good definitions? Does it have good training? Does it have all the elements that the EEOC has prescribed in the 2016 report and the court cases in the jurisdiction you're working in call for? And this is just my own personal opinion that, you know, in the years that we suffered after the Great Recession, a lot of employers didn't necessarily have the money or resources to do the kind of training and do the kind of updates that needed to be done by employment lawyers. So maybe one of the positive things that will come out of the current cultural wave that we see in the United States is that some of this training and some of the policies, manuals, procedures, and contracts will be written in a more clear fashion, and that employment lawyers will help workplaces become places that are friendly and safe for people to work in. If they're not, we have the remedies as we described under these laws, under these statutes, and under the protected categories. So again, for our Employment Week exercises, you'll be taking a quiz. You'll be writing what is one of your major memos of the semester on the Rif exercise, or you'll be engaging in that in the in-person class. In addition to that, you'll have 2 very interesting discussion forums to round up the end of this semester. And that is, there'll be one on OSHA, which is another workplace law, the Occupational Safety Hazard Act, which protects people in the workplace. And you'll be taking a picture for me of some OSHA sign that you see, whether it's at your health club, your workplace, or here at MCC. That is an OSHA regulation sign to show me that you understand OSHA regulations. But you'll also be discussing the case of Declan Sullivan, the young man from Long Grove who fell off the football scaffolding at Notre Dame while he was filming the football team when winds were over 60 miles an hour and died. So you'll be reviewing that OSHA case in particular, but you'll be identifying for me that you understand OSHA's presence in the workplace. And you'll also be looking at, which is my final point for today, the case of the Iowa dental assistant who was with her employer for 10 years, part of a team of almost a dozen dental assistants, when at some point began receiving subjectively sexually harassing kinds of innuendo-filled texts from the dentist that she worked for, which his wife also saw and received a pink slip. And her first team of lawyers took to the all-male Iowa Supreme Court that she was protected under Title VII under the protected category of beauty, and that she should have not been terminated for being beautiful. But if you read that first decision, the all-male Supreme Court in Iowa, and even under the reconsideration motions, said we don't have, and you didn't hear me say it, students, that beauty is not a protected category in Iowa. And it's not a protected category under the federal Title VII. It wasn't in that list I read you. However, if she had been in Madison, Wisconsin, Maryland, or other states and municipalities, there are local ordinances and state laws that actually do have beauty written in as a protected category. In addition, they also have a protected category you also did not hear me read at the beginning of the lecture today, and that is of obesity. That is becoming a protected category, and it's coming along in various state and local jurisdictions, so you need to look at both municipal law and state law. And there are places where you should definitely not say someone is ugly and fat because they have added obesity and beauty to their protected categories, whereas the federal government has not. So you will receive a quiz question from me on this, and you want to read it very carefully, because if I ask you if there is a federal protected category under Title VII of obesity and beauty, the answer to that is no. Does that mean that if I asked you a true and false question and said, is beauty and obesity protected, true or false, beauty and obesity are sometimes protected categories in the United States? The answer to that is true, but you have to know where you live as to what protected category has been added or subtracted by the local law enforcement folks. So I encourage you to enjoy reading about what happened in the second and third round of the dental assistance case, as well as responding to the OSHA case about Declan Sullivan, conducting your quiz, and writing your RIF memo for the employee that you want to protect in the job, and tell the boss that these are the riskiest factors to use. These are protected categories under federal law, and that person should not be terminated. Have a great week.